Hey everybody, how's it going? And welcome to Daily's 2A News. Now, you've probably already heard that the Supreme Court has decided to take a Second Amendment case. Now, this is a big deal because the Supreme Court hasn't heard a Second Amendment case in a long time. As a matter of fact, there was recently almost a dozen cases that were sitting before the Supreme Court for a decision on whether they would want to hear them or not. They decided to kick all of those cases back down to the lower courts and didn't hear a single one. So this is a big deal, but this has huge implications, especially for people that live in New York and California. You live in California, you can't get a permit. Guess what? If we get a good ruling on this one, you could be getting your permit. Okay, so the case that we're going to be talking about today is the NYSRPA, or the New York State Rifle and Pistol Association v. Braun. I think it's pronounced Braun. It's spelled B-R-A-U-E-N. So, correct me if I'm wrong, but I think it's pronounced Braun. So that case right now is actually set to be heard by the Supreme Court. Now, that one's a big deal because it involves the whole good cause clause that is required by some states and some counties to get a carry permit. Good cause is basically saying that if I am applying for a permit, I have to show good cause that my life is in danger, like right now. I have to show proof that I need a permit because there's an imminent threat to my life, and without it, I am in some serious trouble. Almost nobody is able to prove that. For instance, I used to live in California up until about 2 years ago. I lived in LA County, one of the most restrictive counties in the entire state. Nobody gets a permit there. Out of millions of people in that county, there was just, at the time at least, a little bit over 300 total permits issued, and most of those permits went to people who carried money. It went to retired law enforcement, retired judges, active judges, and stuff like that. So people who knew people that would be able to get them a permit. Just the average ordinary everyday citizen was not getting a permit in LA County, period. That was just the end of that, because of that good cause requirement. So the Supreme Court is going to be looking at the constitutionality of that one requirement. If they find that that requirement is unconstitutional, then states like New York and California that use that requirement in order to justify granting somebody a permit will basically be completely turned back and forced to issue permits. Because as we speak right now, that's the current law. So right now in California, at least, the sheriff for that particular county gets to decide whether or not to use good cause and what good cause is. There's not like a uniform good cause requirement as you go up the state. For instance, in LA County, there's good cause, and you have to prove that good cause. But right next door that shares a border is Ventura County. In Ventura County, you can get a permit. It's still a process and kind of a lengthy, time-consuming, expensive process, but you can get a permit. In LA County, right next door, from one invisible border to the other, you can't. So it would really kind of roll things back and allow people to get their permits in places that they just weren't able to before. So this has broad implications across the entire country. The great thing about it is that if we get a positive ruling from the Supreme Court here, it keeps other states from implementing a similar rule. So as you know, as people kind of move from these liberal states into more conservative states and kind of change the politics there, it basically ensures that we're not going to see the good cause requirement be implemented in other states and other counties across the country as things kind of move around and change. So it wipes that off the board completely. So hopefully the Supreme Court gives us a good ruling on this one, sees that it is in fact completely unconstitutional. Period. I personally think that a permit at all to carry is unconstitutional on its face, because anytime you take a right and you put a permit in front of it, it's no longer a right, it's a privilege that's granted to you by the government. And so you can't take somebody's right and turn it into a privilege. You've, broken the legal law of the Constitution itself. But still, at least it would be a positive step forward in the fight for our Second Amendment rights. Now, the FPC is filing a brief in this one. Those things, it's very expensive to do all this stuff. So make sure you support the groups that are fighting with us on this one so that we can get that positive ruling in the Supreme Court. Become a member of the FPC, the New York State Rifle and Pistol Association. Donate when you can. That helps them get into court. That helps them file these briefs. It helps them fight against these just tyrannical people who just don't want to see our Second Amendment rights exist at all. So anyway, hopefully we get a good one on this. I will keep you guys up to date as to the movement on it and when it's going to be heard and what the ruling is. So if you haven't subscribed yet, please make sure that you do so. The like button is always much appreciated. You guys have a great day.